Hi everyone, this is Attorney Aaron from Indiana. I have a new video for you. Let's get started.
All right, I am ready. Miss Yally, you want to call him?
Sure. Do we have a reds list if we do?
We did not get one and everyone was not in red today.
Yeah, I
Okay.
likewise did not get a reds list, and I think I actually see one red in the back row.
Maybe the jail wants to let us know who that is.
Yeah, we have a couple, Your Honor.
Yeah, if you'll call him, let's get him going.
Rebecca Harrison, and we have Cynthia Fontaine and Stephen Flood. I'm sorry. Three.
So, Your Honor, as Rebecca Harrison comes up, I think that's the first name he called. I do have my concerns about her mental health.
Competency, you mean?
I'm tired.
Miss Harrison, how are you doing this morning?
I'm tired. What do you want?
Ma'am, do you understand why you were arrested?
No, I just you figure it out.
Did we just figure it out? Okay.
I'm just not gonna have lunch when I got down.
Okay. Residing at NAMS. I share Mr. Conway's concerns here. I'm inclined to have a competency evaluation ordered in this case, and then bring her back once we get the eval. Application refused to answer. I'm going to appoint a legal defender in the interest of justice, at least temporarily, until we figure out.
Here, the judge is obviously concerned with competency with this defendant. It was pretty obvious that she's not doesn't know why she was arrested, and the court's not going to proceed with anything with this initial hearing without a competency evaluation being completed by a medical professional. So, moving on to the next case.
On here, I'm going to order a competency evaluation, and we'll bring her back once we have the results of that evaluation. Anything from the city on this one?
No, Your Honor, I would not oppose, of course, a competency evaluation.
Okay, thank you very much. Let's make sure she gets protected there. All right, next matter, please.
So the next matter would be Cynthia Fontaine, 23 CR 02253. That is a trespass. And today is the bail hearing, Your Honor.
All right.
Similarly, Your Honor, as she comes up, she may be okay, but she doesn't have a lot of memory. I tried to ask her what her criminal history were. She says she's had some memory problems in her past. Whether she's competent on today's incident, that's what the court should probably just canvass her on. But I did have a conversation with her. I just think she has some memory lapses, is what she.
Okay. Ms. Fontaine, we're going to chat for a few moments because I want to make sure that we're in the right place at the right time with you. Ma'am, do you understand why you were arrested?
I don't understand why I was arrested at a hospital when I needed medical treatment. I got hit badly, so it doesn't make sense to me.
Okay, are you aware that you were asked to leave and then you didn't leave?
Yeah, but I also was hurting to walk for one, and on top of that, like I want surgery, and like I have a PTSD in hospitals.
Okay.
Especially
Well,
when I'm alone without.
I'm hearing a pretty cogent statement of an understanding of what happened. Certainly she has her opinion on the validity of what happened, but
On this second defendant, obviously she knows why she's there. She remembers being trespassed from the hospital. She just doesn't agree with it. So it looks like the judge is going to proceed with the state and the defense here. As you all know, I'm a defense attorney, so I'm pro-defense most of the time, and I'm hoping that we'll get her a bond so we can get her out of jail here for a misdemeanor trespass.
I don't have competency concerns on this individual, so I'm comfortable proceeding forward on bail. Let me hear from the city first, please.
So, Your Honor, as you know, this is a trespass, so it's not a super serious misdemeanor. The bail looks like preliminary set at $500 bondable. The pretrial assessment report indicates that she has a suspended sentence. So that is out there for your consideration. I would request that that the 500 bondable remain. It's quite low. It looks like she doesn't have a fixed address.
Again, it strikes me, you've got a prosecutor here saying she doesn't have an address, she doesn't have support system, but you want her to post $500. Where would she get that? If she can assure the court she can attend the next hearing or the following hearings, and she can give them a valid address and maybe even a phone number where she's going to be, how they can get a hold of her, she shouldn't be held for a misdemeanor trespass offense. This is a situation where nobody was hurt. There would be other charges, and 500 seems steep.
No means of support, no contact information. So based on that, I don't have a lot of reassurances that she would appear for her hearing. I would ask that she be put into her arraignment hearing on Monday, if that's a possibility.
Okay, Mr. Conway.
Your Honor, I am going to ask for a release on their own recognizance. I don't like these cases out of the hospital. People are trying to seek help, and then, and I understand the hospital has its viewpoints, but I just worry about that. In reviewing the interview notes from the pretrial assessment, I'm not seeing a failure to appear, which is one of the factors that the court has to consider about in the event of posting or requiring a posting of a bond or bail. I don't see that here. So I don't have, and if she has an older case, again, there would be maybe a history that she had failed to appear. It doesn't say that. So she must have appeared and taken her suspended sentence and gone on from there. So I'm going to request the court to consider a release on her own recognizance. Obviously tell her she needs to seek medical help elsewhere at this point. But that's what I would request.
Ms. Ballard, if I were to impose bail and if Ms. Fontaine was not able to make bail, could we get her to the arraignment hearing on Monday?
Yes, they're all scheduled for videos on Monday.
Okay. The reason that, so Mr. Conway, I generally agree with your analysis and assessment here. I do have an indication that Ms. Fontaine does have a previous failure to appear warrant in the declaration. I don't see court records indicating failure to appear. Ms. Ballard, can we pull up the docket in a case real quick and see if we can see if there's a failure to appear note in there? And I'll tell you point blank, that's kind of the threshold question for me on whether I'm going to keep the bail in place or whether I'm going to go OR on this one. Can we get into?
I do not see a failure to appear.
And you're looking at 22 CR 16583.
Yes.
Okay. All right. I have some concerns about an OR release, but especially since Ms. Fontaine appears to lack the means to support herself, which I hear from the city. I also suspect that that means she lacks the means to post bail, which means that any bail amount would be tantamount to a no bail hold. Given the nature of the offense, I don't think that that's appropriate. I don't see any indication of violence in the trespass, just a little bit of yelling. Given what I perceive to be the low risk to the community, and given that she has apparently successfully gone through court proceedings and has made her prior court dates, I'm going to go ahead and lift bail, release her on her own recognizance. I will order that she stay away from Northern Nevada Sierra Medical Center located on Innovation Drive, unless she is for some reason transported there in the case of emergency. Certainly if an ambulance takes her there, that's not her fault. Ma'am, we're going to release you. We're going to give you a court date for your arraignment where you're actually going to appear and enter your plea to the charges. And I need you to understand how critical it is that you appear at that date. I'm letting you out because it looks like you've been pretty good at coming to court. If you prove me wrong on that one, we're going to pick you back up and we're going to hold you until we can figure out what to do with you. Do you understand all that?
Yeah.
Okay, and you understand that you can't go back to Northern Nevada Sierra Medical Center, at least while we're getting this case processed, but certainly if an ambulance takes you there, that's not your fault, not your problem. You understand all that? Okay, that's gonna be the order of the court. Let's get you on your way. I will take no action on the suspended sentence. Certainly if the judge in that case has a different view, there may be something there I have no control over.
Well done. I appreciate the judge doing what he said he was going to do. Once the court reporter checked and seen no failure to appears, I believe the right decision was made here. I agree. Hopefully she gets to court and gets this behind her. Sounded like a misunderstanding. These are the type of things where people just, they need the court system work it out and get the people on their way. This is not a serious offense.
You understand everything, ma'am?
Yes.
Okay, we'll get you on your way. Thank you, ma'am.
I thank you.
Okay, next case will be Tyler Amir.
That's
20
Stephen Flood is the last red.
Oh, I'm sorry, I didn't realize. Okay. So Stephen Flood would be 23 CR 02257. Mr. Flood has a possession of open container, and today is the bail hearing.
Okay. And I will just put on the record, I've had Mr. Flood in videos previously, but also in my capacity as an attorney, because I'm a pro tem judge. Mr. Flood did contact my office to see if I could help him in a matter related to the city. Obviously, given what I do for the city, I told him that I would not be able to assist him. However, if that causes any concerns for either the city or for Mr. Conway, I'm quite happy to recuse myself from this matter.
I was going to just say that I'm not objecting to an OR release in this matter, so for whatever that's worth.
And I will tell you candidly that my inclination is to do an OR with a stay away from the VA facility until we can get the arraignment set, and I'll allow not allow, but of course the arraignment judge will be able to revisit that stay away condition. So that would be my inclination. But given the fact that I do know Mr. Flood a little bit more than the average individual here, I wanted to get that out on the record. And if it causes anybody any concern, you know, I'm happy to defer. Mr. Conway, what do you think about all that?
Yeah, I have no objection to that, Your Honor. He's also got a charge in Reno Justice Court, so he's got a lot of fish to fry. So I think ORing him on this is probably appropriate, and then he's got to deal with that and just realize that his failure to deal with RJC could result in him being thrown back in custody on our case.
Right. Yeah. And Mr. Flood, I know you've been hearing this, and I've talked to you before, so I know you understand what's going on. I'm going to release you on this matter, but I understand you have another matter, so I can't touch that one. That doesn't have anything to do with me. For purposes of our proceedings today, I am going to order that you stay away from the VA.
As you can see, the defendant's raised his hand 3 times, obviously wanting to speak. Right now, he's getting what he wants. He's going to be OR'd in this matter, and everybody's agreeing to release him. It would serve him well not to say anything, just to thank you and move on. It's interesting. The judge in this court obviously also does some defense work because he was contacted by the defendant to be hired. So he must be a part-time magistrate or commissioner here or something for the city in this court. So interesting that that's the dynamic, but obviously did the right thing by asking the state and the defense if they thought it was necessary for him to recuse himself. All that would have done is delayed the inevitable of an OR for this defendant. So the right thing's being done here. Hopefully this defendant doesn't mess anything up by speaking here. Looks like he's getting ready to talk.
Until the arraignment, unless you are transported there for an emergency. Do you understand that?
Medical care, I have upcoming appointments there that I have to make. The county, I just had a hearing on that. They did not put a stay away on that due to my medical treatment.
And Your Honor,
What's the medical treatment? And Mr. Conway, I apologize. I think we're about to ask the same question at the same time. Mr. Conway, go ahead.
I was just going to say that if he has appointments, I think he has a right to go. I don't think you can keep him away from there. He has to be there for legitimate business. We do the same thing with the hospitals often. If it's one of the main hospitals, we'll say you can go there if you're there for a legitimate purpose.
And that's exactly where I was about to go. I was going to tell you, Mr. Flood, if you've got pre-existing appointments there, You can keep your appointments, but I don't want you there for any reason other than your appointments. Do you understand that, sir? Okay, all right, OR, only, kind of a modified stay away order from the VA. You can only go there for legitimate business, that being your pre-existing appointments. And arraignment judge can revisit or will revisit it at time of arraignment. Best of luck to you out there, sir.
Sir.
Okay,
Three cases. One person's going to sit for a while for a competence evaluation by medical. The other two are released. It's a good day in that court. We'll see you next time.